Okay, let's now bring in Mr. Oluwadare Kolawole, who is the Deputy Director of SERAP, Socio-Economic Rights and Accountability Project. Mr. Oluwadare, good to see you again.
I'm happy to see you again.
We always say SERAP is always in the news. But let's get the big elephant out of the room. First off, before we come to this issue that is you're demanding, I mean, SERAP is demanding that governors must be held accountable for what played out in last year's general election across the subnational levels. There was a back and forth as to the issue of the DSS that, they sued SERAP for defamation to the tune of 5 billion naira. And from what I read, they are saying that, look, they approached your facility as a routine exercise to acquaint themselves with new leadership within the centers where they operate. And the person in your office has said, look, the people that you want to see are not here. You should have written, maybe you come back later. And they say as they left, they were surprised to see that the organization put out an information saying, hey, your office was raided. And then it gave rise to the litigation that, and in fact, they are saying that 2 persons were suspended to that effect within the organization, and within the DSS. So it's a back and forth between you guys and the DSS. So what is the true picture of things, and where is that case at the moment?
Thank you very much. I would only be able to speak to these briefly without touching on the subject matter that is already in court. So, but the facts in the public domain is that the DSS has gone to court and they've made these allegations against SERAP about what they thought they had a case for defamation. But I think what has been established so far is that the DSS indeed visited our offices and that it was an invasion. As to the merit of the case they filed, I would leave that to be argued by our lawyers in court. And ultimately, we are sure that the court will agree with us, or I can say the court will agree with Nigerians in this instance. And a very simple explanation would suffice. What has been the character, the antecedent of the DSS that would not amount to an invasion if they visit any offices, particularly when they could have done that formally instead of doing it informally like they've alleged? And really, the fact is also clear. There has been no new leadership in SERAP, so to speak, that would warrant what they called the familiarization. But I'm sure our lawyers are presently preparing our papers, and we'll join issues with them in court. But I do know clearly that this is just one of those antics, those strategies to intimidate and to harass SERAP into silence.
Mr. Oluwadare, I'm happy you didn't speak to the substance of the case so that we won't be preempting outcome at the end of the day. But I needed you to speak to it because I think this is the first time we're having you here since that issue came up. 5 billion is a lot of money, and defamation and all of the issues around it. But let's talk about the very substantial issue here that has to do with SERAP saying INEC rise to the occasion. You are alleging that governors may have exercised some malpractice in terms of how people were elected into office, and you're insisting that INEC must investigate and bring everybody who is responsible and culpable to book. This call you're making, have you gotten any response from INEC?
No, and I think it's better we put this in context. Thank you very much for that question. What happened during the 2023 general elections in various states in Nigeria, according to reports that is the public domain, incidences that are that offend the clear provisions of the Electoral Act, where political office holders were alleged to have been involved. And INEC, being the sole umpire in the electoral system, particularly the general elections, has that duty to investigate and prosecute. That is the clear provisions of the Electoral Act, which INEC hasn't done. So we wrote to INEC last year for INEC to do that. INEC did not respond. Then we went to court. And then the court, in hearing this case, decided in July this year, mandating INEC to do those things that we've asked INEC to do, which is basically to investigate those allegations and to prosecute those offenders. And I also like to point out again that the Electoral Act puts these responsibilities squarely at the doorstep of INEC. It is not the job of the police. It is not the job of any other law enforcement agencies, even though they can act, but it is the job of INEC. That is what Section 145 of 2 of the Electoral Act says. And the court agreed with us, that's Honorable Justice Electoral of the Federal Court of Abuja, who gave an order mandating INEC to investigate these allegations and to prosecute those who are found culpable. Of course, that will be subject to the judicial process. INEC did not obey that order, even though we also took a step to write to INEC. The letter was delivered in August this year. We also wrote to INEC requesting INEC to obey the judgment of court. And that is what has premised SERAP, acting through our lawyers, to start what is called this contempt proceedings. It is a proceedings, it's a procedure in law to compel any judgment debtor, that is someone who one has judgment against, to obey the judgment. So that is where we are presently, taking legal steps to compel INEC to obey the judgment of court, to do its statutory duties as clearly stated in the Constitution and the Electoral Act.
And so, Mr. Oluwadare, we await INEC's response to, your demand for it to obey the court judgment. But some would say, as far as SERAP is concerned, that there is no deficit of suits, but that there is, in fact, an abundance of suits, and that there are organizations funding your work as a civil society organization, and that, as a result of that, some of what you do, or most of what you do, is, in fact, perfunctory and lacking in substance in the outcomes, which would be ensuring the accountability itself. Some think that, when these suits come out, that government looks the other way. How do you respond to this?
That cannot be true, but that wouldn't be surprising, depending on which quarters this kind of thinking is coming from. Perhaps for those who might not understand the judicial legal process, and perhaps for those who simply want to be mischievous, who choose not to understand the legal process. And that is why I like the provisions of Section 6 of the Constitution that has empowered individuals, organizations, including arms of government, to subject whatever grievances they have to the court. Is that not the basic principle of the rule of law? And that is what we've done. And that is what we do from time to time. Even the DSS, when it thinks, wrongly though, that he had a case against SERAP, approached the court to ventilate its grievances. And that is what SERAP has been doing. It is called public interest litigation. It is also called strategic litigation, using the tools of the law to compel public institutions to act on behalf of the people, in line with the various legal frameworks that guide the operations of the Nigerian government. That is all we do. And in this instance, like we spoke so few minutes ago, we had gone to court to compel INEC to do what it ought to do, prevent further electoral malpractices in future elections. Did not obey. We didn't do anything wrong. We went to court. And you would see from the various judgments that we get from the court agrees with us because of the principle of law involved and because of the facts available to put before the court. Same court gave judgment on behalf of SERAP. And you would think that the best the INEC would is to obey the judgment. So
speak to the substance of the matter. How many judgments do you in fact secure in your favor in all of these suits? For instance, the one filed in May compelling former Minister of Information, Alhaji Lai Mohammed, to disclose the details between the federal government and X in that case at that time. Did SERAP get a favorable judgment? Just to mention one out of the many suits that SERAP files demanding accountability from government officials.
Yes, we do get judgments. And I think the most important thing in this advocacy is to compel for the citizens to join voices with the SERAP to compel government to obey this judgment. And I'm happy you referred to that judgment. It took 2 years in court. The court eventually agreed with SERAP again and gave judgment compelling the Ministry of Information to provide the information, the agreement the government allegedly signed with X, which of course was the basis of what the minister at that time had said as Twitter, now X, was reopened at that time. It's just one of many. This INEC judgment is the second. Again, we got judgment in 2019 compelling the Attorney General of the Federation, and you would agree with me that governance is a continuum. So just because the former Attorney General had left office does not remove government from responsibility. The court at that time, Honorable Justice Ogutoyibo, now retired, mandated the Attorney General of the Federation to go to court and to challenge the legality of state pension laws, which, by the way, means that former governors and former deputy governors and billions of naira cumulatively at the expense of poor taxpayers in Nigeria. That judgment is yet to be obeyed. A court in Abuja last year also gave judgment on behalf of, in favor of SERAP, compelling the federal government to disclose how the funds, the loans that were procured from China to install CCTV and other security infrastructure in Abuja have been spent. That judgment, as I speak to you, is yet to be obeyed. And this is just mentioned 4 or 5 of the many judgments that SERAP had gotten from court, which are basically issues of transparency and accountability right from the inception, no matter which political party has been involved, no matter which public institution has been involved. And this shows the consistency of our action. And I think, if anything, this legal advocacy should be appreciated to be a way of towing the path of the rule of law rather than any sort of unlawful act, which of course SERAP will also strive to. And I think the next line of advocacy is for the people to prevail on government to obey this judgment. And when you look at all these judgments, it favors SERAP personally. They are all public interest lawsuits compelling government to act on behalf of the people, knowing fully well that those who are in power, those who are still in power, will eventually return to the citizens. And even this same judgment will favor them. But unfortunately, spending time in court and getting judgments has not really given that benefit for Nigerians.
There's a lot of that as we begin to wind down. It's perhaps what Bukola is talking about is what I can call litigation fatigue. A lot of people have had SERAP suing every other Sunday. SERAP is either suing or writing a letter. But we must commend you for what you do, putting the government in check. But in terms of, we see also compliance hesitancy and even disregard, literally, because I don't know where or how many of these judgments have been in favor of SERAP has been obeyed or respected or even followed through at the end of the day. So what is left for you in your kits of action when these things happen? Because these are very important issues. If people committed malpractice in an election, which is a hiring process every 4 years, is a very serious infraction on democracy. And those people should be checked. If the institution responsible for checking them is not doing anything, then where does SERAP go from here?
And that's what we're doing presently with these suits against INEC. Our lawyers have commenced what is called contempt proceedings. This is a proceedings in law that compels anyone with one as judgment against to obey the judgment of court. Unfortunately, we shouldn't be doing this, but that's where we found ourselves. So we have filed what is called in law Form 48, which is basically a notice to the judgment to INEC in this instance, giving them notice, and that speaks to the head of INEC itself, to show cause why he should not be committed to prison for not obeying the judgment of court. They've been served that process more than a week now, and the next process is to get a date for him, because of course, even though it's a judgment enforcement procedure, the court still gives the other party, INEC in this instance, the opportunity to defend itself. And we've seen that happen in a lot of instances, even with agencies such as the EFCC. So the next step in this procedure is to have INEC show cause to the court, and not to SERAP in this instance, why he does not obey that judgment of court.
Based on trend, I don't know what will come out of this, but we hope for the very best. We hope that there'll be a day when action like this will be followed through and through. That's why I asked the question. I know you filed this particular case, this contempt case, and what will not happen if it's still not obeyed and all of that. But we're totally out of time. Mr. Kolawole Oluwadare, Deputy Director of Social Economic Rights and Accountability Project, SERAP. Thank you so much for coming through, and thank you for the work you do at SERAP.
Thank you very much. I appreciate this opportunity.
Absolutely. Bukola.
Yeah, that's how it's been on the first edition of the show today. Thank you so much for being there. Of course, it's just starting. The week is unfolding. We'll be back again tomorrow with another bumper package for you. I am Bukola Koka. Have yourselves a wonderful day.
I don't want to say anything about bumper, but thank you so much for your time and, of course, your usual company. Sunrise Daily is up next at the top of the hour. See you later on. Thank you for watching.